Namaskar friends, I am Anil Kohli, Insolvency Professional. Today I'll try to share the knowledge which I have gained through experiences in the various processes under the code. So today's topic is contents of the resolution plan and its approval. However, I'll take you through some basics of insolvency and its resolution. So insolvency basically is the situation of commitment of default in payment of the dues owed by the corporate debtor. So whenever a person or a corporate debtor is not able to clear his dues, that situation will be called insolvency. And the resolution is the bringing out that person or the corporate debtor from that situation of default. Basically, the resolution entails three situations. First is the diagnosis of the cause of the default. And the second would be the identification of the treatment for that cause. And third is the real process of this treatment. So the resolution plan, it's a document enlisting all the three above things, which is the cause of the default, then the identification of the problem, and the treatment, and thirdly the process of its treatment, which will be the implementation of the plan. So today's topic is contents of resolution plan. Now I will take you through the various legal provisions in this regard. First of all, coming to the definitions, as I have explained you, this is the definition given by Oxford Dictionary. Insolvency is the state of not having enough money to pay what you owe, an occasion when it happens. This is Oxford Dictionary's definition. And resolution is the act of solving or settling a problem, disagreement, etc. This definition has also been given by Oxford Dictionary. Then comes the situation of resolution plan. So as per section 526, the resolution plan means a plan proposed by resolution applicant for insolvency resolution of the corporate debtor as a going concern in accordance with the part 2. So for removal of doubts, it is cleared that the resolution plan may include the provisions for restructuring of the corporate debtor, including by way of merger, amalgamation, or demerger. Basically, friends, the resolution plan will generally include management change. Since the earlier management had not been able to handle the affairs of the corporate debtor, due to which this position has reached that the corporate debtor is under the default. So the resolution plan basically will provide for measures like which have been enlisted in Regulation 37. The Regulation 37 provides the basics of the resolution plan. So the resolution plan of a corporate debtor for maximization of its value of the assets will include the following. First is transfer all the or part of the assets of the corporate debtor to one or more persons. Then will be the sale or part or all assets, whether subject to any security interest or not. The substantial acquisition of shares of the corporate debtor is the third thing. So by means of which we will change the management of the corporate debtor. Or there may be a merger or consolidation of corporate debtor, since there may be some institution which is already in the same business that may merge this corporate debtor into its own entity, and there will be a new entity which will run smoothly and will have no default. And then is cancellation or delisting of shares of the corporate debtor. So satisfaction or modification of security interest. Since, as you are aware, that the resolution plan basically would try to bring out the company out of the default, and basically what will happen is that in this process, they will try to take it at a real value, and with the real things which are not, against the required issues, required assets, or required valuation, which is good for running of the corporate debtor smoothly in the future at least. And there will be another thing, curing or waiving of any breach of the terms of any debt due from the corporate debtor. Then reduction in the amount payable to the creditors, that will be another thing. Then is extension of a maturity date or a change in interest rate or other terms of the debt due from the corporate debtor. Since generally what happens, friends, generally the issue comes is when a corporate debtor is burdened with a debt which is not consonant to the size of the corporate debtor, which is not consonant to the earnings or revenues of the corporate debtor. There may be higher investments in the fixed assets. There may be lower working funds left for the working capital. Therefore, to take out the corporate debtor from such a situation, generally what is done is the debts instruments or the earlier contracts or the earlier assets, these are the technological issues are corrected by way of a resolution plan. So these, as I have told you, these are the things like an amendment of constitutional documents of corporate debtor, which may also bring out the corporate debtor from the situation of this, issue of the default. This is another. Then the issue of securities of corporate debtor for cash or property, securities or in exchange of claims or interest and or other appropriate purpose. Then is change in portfolio of goods or services produced by the corporate debtor. Maybe certain goods are not as per the standards of the market. There may be an advancement in the requirements of the consumers. So there may be, the resolution plan may include such a statement of change of the nature of the goods or services. And then, as I told you, the change in technology. That is another big issue due to which certain corporate debtors have come into default, like CDs. These were running earlier. Now there is no requirement of CDs, and generally it's all on the web, the OneDrive, or these are the modes of storages. So the CD business will fail in such an circumstance. Then is obtaining approvals, necessary approvals from the central or state government or other authorities. This may also be one of the proposals in the resolution plan. Then comes, friends, the Regulation 38, which provides the mandatory contents of the resolution plan. And the contents basically are the amount due to the operational creditors under the resolution plan shall be given priority in payment over financial creditors. It does not mean that the operational creditors have to be paid their entire dues in priority. Generally, it is specified further, we will come to that in the regulation, that the operational creditors, their liquidation value owed to them must be paid in priority. And also sometimes, the resolution applicant, he may feel that he requires certain operational creditors necessarily for the smooth running of the corporate debtor, like transporters. Generally if the local transporters are not paid in time, so then there may be an issue in running of the business and they may not provide services. Sometimes electricity dues, there are issues if you do not have cleared the dues of the electricity. So these kinds of situations, these will depend on the resolution applicant, how much he wants to pay, but the minimum is the liquidation value. Then is the resolution plan shall include a statement as to how it has dealt with the interest of all stakeholders, including financial creditors and operational creditors of the corporate debtor. And a resolution plan shall provide the terms of the plan and its implementation schedule, that is definitely required, how much time it will need to make the entire payment till the handover of the corporate debtor, what is the term of the plan, how much time it will need to change the technology or the goods or services. These kinds of issues may be are the required contents of the resolution plan. Then is the management and control of the business of the corporate debtor during its term. So basically, that CRP ends when the plan is approved, and till the handover of the CD to the resolution applicant, there is an interim term. So during which generally what happens is the monitoring committee comes into play, and the monitoring committee will consist of basically the resolution applicant himself, the financial creditor, and the resolution professional or any other person appointed as a monitoring professional who will jointly supervise the affairs. Like in the next provision, it is adequate means of supervising its implementation. So these are the mandatory contents of a resolution plan. Then comes to the 38.3, which says a resolution plan shall demonstrate that it addresses the cause of the default. As I have told you in the beginning, that the identification of the cause of default is the basic requirement. Otherwise, if we do not know the disease itself, the cure would be very difficult. So, and it should demonstrate that it is feasible and viable, and this has happened in various matters, that the resolution applicant has not been able to implement the plan given by him, and therefore it is a mandatory requirement that the COC examines that it is feasible and it would be viable to be implemented. It should not happen that the RA fails and again there is a default situation, which will be not good for the process itself and for the economy also. Then it must have a provision for its effective implementation, that is through the monitoring committee generally. Then it has the provision for approvals required and the timeline for the same. The resolution applicant has the capability to implement the resolution plan. Then again, which I am saying that they have some resolution applicants have not been able to fulfill their own commitments or their own proposal. Therefore, it is now being seen very seriously that he should also have the capability to implement it. Then coming to the sections, these were the regulation. Coming to the section 30. It says about submission of the resolution plan. Basically, the process of submission of resolution plan is entailed here. First is the resolution applicant may submit a resolution plan along with an affidavit stating that he is eligible under section 29A. Basically, this has been introduced to avoid the owners coming again into the resolution process and taking over the CD through back door. So this provision has been brought in by way of an ordinance earlier, then it was enacted as an enactment. So, to the resolution professional prepared on the basis of information memorandum. So, affidavit is one requirement and the information memorandum another important document which gives all the details about the corporate debtor. So, the resolution applicant can take help of the information memorandum to get the required information about the earlier issues with the corporate debtor, its entire assets or the financial strength. So, he can plan his further process of taking further the corporate debtor into a solvent situation by means of this information and incorporating into his plan. So, the resolution professional has to examine each and every plan received by him to confirm that each resolution plan. So, before that I would like to add on, there is another section which is section 25. So, as per section 25, we have to submit all the plans before the committee of creditors, whether compliant or not. So, we generally what we do is we put before the committee all the sealed envelopes or the password protected financial bids, so that to ensure the transparency for the financial creditors, they are aware that fine, there has not been any misdealing in the process, and the plans are opened before the committee and then the basics are read out, and at this stage only the resolution applicant gives his presentation so that to inspire the confidence of the committee members. So generally on this first meeting after the receipt of the plan, the plans are open and the presentation is done before the committee of creditors to inspire their confidence that yes, there is a person who can take out the corporate debtor out of this situation of default. So then after this, section 30 subsection 2, which gives the basic requirements for the resolution plan, this is the most important section, that the resolution professional has to ensure that it provides for in payment of insolvency resolution process costs in a manner specified by the board in priority to the payment of other debts of the corporate debtor. Then IRP costs are the first priority. Then it must provide for the debts of operational creditor in such manner as may be specified by the board, which shall not be less than the amount to be paid to the creditors in the event of liquidation of the corporate debtor under section 53. So basically, as I was telling you, the liquidation value must be ensured to the operational creditors so that they are not put in a position which is worse than the liquidation stage. What happens is the operational creditors are not a party for voting. They cannot vote to the plan. So therefore, to safeguard their interest, to protect their interest, the law has provided by itself that they should be ensured at least the amount which had been received by them in the stage of liquidation, which is the worst possible scenario under this the Insolvency and Bankruptcy Code. So second is the amount which would have been paid had the amount to be distributed under the resolution plan. Basically, whatever has been provided under the plan. So whichever is higher out of the two, the liquidation value to the operational creditors or the amount to be paid to them as per the plan. So whichever will be higher will be generally paid to them in the plan. And then then the amount which shall be paid to the creditors in as per section 53. Again the priority is described under the waterfall mechanism, which is section 53, which comes into play in the stage of insolvency. However, the law has now incorporated in the resolution process also, so that the priority of the creditors is maintained and the resolution applicant is not able to do certain adjustments for securing the votes. He may give preference to one of the financial creditor for seeking his vote. So to safeguard all these things, the law has now incorporated the waterfall mechanism in the resolution process also. So explanation says that for removal of doubts, it is clarified that a distribution in accordance with the provisions of this clause shall be fair and equitable to such creditors. So law is depending on the morals of the COC and the resolution applicant also, resolution professional, so that fair and equitable distribution is done to the creditors. Then second explanation is given that this is regarding some Amendment Act 2019. So this all these provisions will apply to the plans if at all still pending, for approval. So to those processes also, this provision will be applicable. If the plan has not been approved or rejected, but it is lying with the adjudicating authority, then we have to apply these provisions and get the plan modified accordingly. Then is where an appeal has been preferred against under section 61, 62, and such appeal is not time barred under provision. So there also this provision will be applicable. Or wherein a legal proceeding has been initiated and in court against the decision of adjudicating authority in respect of resolution plan, there in such situation also these provisions and the plan has to be modified as per the requirements of the law under section 30, subsection 2. So all such plans. And then third requirement is it shall provide for the management of affairs of the corporate debtor after approval of the resolution plan. That is also a requirement. The implementation and supervision of the plan, as we have discussed, monitoring committee. Then is it does not contravene any of the provisions of the law for the time being in force. So that means all the entire laws of the country have been to be taken care of in the resolution plan. There should not be breach of any law by way of any terms of the resolution plan. So the laws have to be protected, and the resolution professional has to examine these facts also before submitting the plan further for approval before the committee. Then is it shall conform to the requirements as may be specified by the board. So regulations have also to be adhered to. So since the board, as you know, specifies under the regulations. So for the purpose of this clause, if any approval of shareholders is required under the Companies Act or any other law for the time being in force for the implementation of actions of the resolution plan, such approval shall be deemed to have been obtained. So what happens is the ownership of a corporate debtor will be through the shareholding. So in this provision, it has been ensured that the corporate debtors, shareholders should not come in between the implementation of the plan. The resolution professional now, section 30, subsection 3, wherein the resolution professional submits the plan for final approval of the committee after ensuring all the compliances with the compliance certificate. So the COC may approve the plan. Now comes to the approval. So up to subsection 30, subsection 3, the contents of the resolution plan were there. Now after submission of the plan comes the approval. So COC will approve the plan by 66% majority, and after considering the feasibility and viability, as I told you, and the manner of distribution proposed as per section 53(1), and priority of the security interest has also to be kept in mind. So, and the COC shall not approve a plan submitted before ordinance. So, this is not relevant because 29A has to be adhered to. So, it's old 2017 ordinance. So, now second proviso shall be not be construed to be extension of period. Basically, there is a requirement that if at all the plan was pending since before 2017, so in such a scenario 30 days will be allowed to the RA to cure that defect. It happened in SR Steel's matter, wherein the ArcelorMittal was provided an opportunity to cure the default of Galva Steel, so Galva Uttam Steel, so that this provision was applied there. So that the eligibility as amended by ordinance will also apply to the resolution applicant who has submitted the plan before 2018. Then the resolution applicant has to be allowed to attend the meeting. Yeah, for negotiations he is required, but he will not have a right to vote there. And the resolution professional shall submit the plan. Now COC has approved it, so the resolution professional will finally go to the adjudicating authority under section 30 subsection 6. Then is approval of the plan by the adjudicating authority. It is covered under section 31. So if the adjudicating authority, first, it is satisfied with that all the compliances of code and regulations have been met, and secondly, it is assured that it will be effectively implemented, that the plan is implementable. In such scenario, the adjudicating authority will approve the plan, and it will also see that after the order of the adjudicating authority, the plan will become binding on all concerned stakeholders, including the central government, state government, local authority, corporate debtor, its employees, members, creditors, and for all the payment of dues will be as per the plan only. So the income tax department or sales tax department cannot ask for their dues after the approval of plan. So where the adjudicating authority is satisfied that the resolution plan does not conform to the requirements, then it will reject the plan. And then 31.3, after that approval of plan, what happens is moratorium ceases to have effect. Then all records are to be submitted by the RP to the board. Then the resolution applicant shall, pursuant to the plan, obtain all the required approvals within a period of 1 year. Then, friends, regulations give the process of approval under regulation 39, that the prospective resolution applicant only whose name is there in the final list can submit the plan. So the list is prepared after receipt of expression of interest, for which Form G is published. So the resolution will be given by only the resolution applicant in final list. He has to give an affidavit under 29A and also an undertaking by the PRA that all the information and records provided in connection with the plan is true and correct, and discovery of any information and record at any time which is wrong or incorrect will render him ineligible, and his refundable deposited by him will be forfeited, and also he will be liable for criminal action, penal action under the concerned laws. Then the resolution professional may, if envisages in the resolution plan, allow modification of the resolution plan, the modification, but only once. So basically what happens is, once a plan is submitted to the committee, there are negotiations amongst the committee members as well as the RA, and then after the negotiations, a final revised plan may be received from the RA, which will be put for approval. Then the RP can use a challenge mechanism also to enable the resolution applicants to improve their plans to enhance the value of the corporate debtor. Committee shall not consider any resolution plan received after time specified by the committee under regulation 36B, or received from person whose name is not there in the final list of PRAs, or which does not comply with the section 30 subsection 2 requirements. Then RP shall submit to the committee all resolution plan which comply with the requirements of the code and regulations, and along with the details of these avoidance applications, which are preferential under 43, undervalued transaction under 45, extortionate under 50, or fraudulent transactions under 66, and the orders, if any, received from the adjudicating authority regarding the avoidance applications. The committee will then evaluate the plans and grant them scoring as per the evaluation metrics, which will be applicable, which will be required only for the tiebreaker formula. We will discuss it later. and a committee will record the deliberations on feasibility and viability of each resolution plan, then vote on all the plans, resolution plans simultaneously. Where only one plan is put to vote, then if it is approved by 66%, fine, it is approved. Then 2 or more are put to vote, then the highest vote gainer will be considered as approved. However, the situation arises where 2 or more plans are having equal votes. Then in such a situation, there is a requirement of tiebreaker formula. So generally what is done is the scoring as per evaluation matrix is referred to in such a situation, and the H1 who has gained the maximum score as per the evaluation matrix, his plan is put for is considered to be approved and given to the adjudicating authority for approval. Here a demonstration has been made how the scoring is done. So basically if plan 1A gets 55 and B gets 60, then B will be approved 70 and 75. Then also B is scoring higher. But 75 and 75, here is the requirement. If 2 plans have got 75, then requirement of tiebreaker formula. Then is the resolution professional shall endeavour to submit the resolution plan for which is approved by the committee before the adjudicating authority at least 15 days before the expiry of the CARP. And the resolution professional will forward the copy of the order of adjudicating authority approving or rejecting the plan to the participant and the resolution applicant. Then also the resolution professional within 15 days of approval of the adjudicating authority will intimate each claimant and the principal or formulae as the case may be for payment of debts under such plan. So we will inform that how your debts are being proposed to be paid under the plan to each and every claimant. So, so all the concerned stakeholders are being informed by the RP that this plan has been now approved by the adjudicating authority, and this is binding on you, by means of which the RA will also be safeguarded from further harassment by the authorities. So this regulation applies to all, yeah. Then a provision which will otherwise require consent of members or partners will deem to have been, as I have told you. No proceeding will be initiated against the IRP or RP for actions under good faith, then or for the actions which have been conducted by the corporate debtor prior to insolvency commencement. Then a person in charge of management and control after a resolution plan then is approved, then he can seek district administration's help also for the purposes required. Then the creditor, if he is aggrieved by the non-implementation of the resolution plan, may apply to adjudicating authority for directions. Friends, this was the provisions, legal provisions which are relevant for the contents of resolution plan and its approval. One subject is there which is negotiations. So negotiation play a very important role, in this process for maximization of value of the corporate debtor. So negotiations generally will include the financial consideration improvement, and then it will also, there can be negotiation regarding the term and duration of the resolution plan, which is aimed at reducing the quantum and duration of deferred payment. And negotiations can also be regarding the conditions precedents. So there may be certain conditions precedent which are not acceptable to the committee. So these can also be eliminated by way of negotiations. Then plan can be made compliant with mandatory contents of the code. Then some clarifications may be sought, or maybe some terms may be improved by the resolution plan. So thank you very much, friends. This is from me about the resolution plan and its approval. Jai Hind. Thank you, friends.